coming up, and I've discussed that with counsel. In general terms, then, noting the dates of the trial, there were a few matters the court wanted to raise, and then I'll get to counsel specifically with any questions or concerns you have about trial. Let me go back to this questionnaire then. The court does intend to and will be distributing a jury questionnaire to start the voir dire process before we begin evidence in the trial. The questionnaire has been now approved in its contents by counsel based on our hearing yesterday. The only remaining alterations will be the completion of the witness list that would be included in the questionnaire, and I will have a final version to be approved by counsel before it's printed off and distributed to potential jurors in Ada County. So knowing that we'll still have that final last look with the witness list completed with that. And who's is it you, Ms. Blake, today for the state?
Yes, Your Honor.
All right. Do you have any other questions or concerns on the questionnaire other than what we discussed yesterday and what I mentioned here this morning?
No, Your Honor, the state has no other concerns.
All right. Thank you, Mr. Pryor. On behalf of Mr. Daybell, anything further to add on that questionnaire?
No, Judge. And as I previously noted to the court, my list of witnesses was provided to your staff, I believe, on either Friday or Saturday evening. So I think I've complied with the court's directive regarding this disclosure of witnesses.
All right. Thank you, counsel. The next topic I guess I'll bring up then, as it does relate to witnesses at trial. The court's entered an order that the trial will be live streamed on the court's channel. The concern that I have there, and would need counsel to instruct carefully any witnesses, there will be an order for exclusion of witnesses, I presume, entered in this case, and that relates to witnesses not observing testimony before they testify. I guess 2 points to bring up there. Number one, if there are victims attending the trial, we had this issue come up and made some decisions on that in the prior case where Lori Vallow's trial went through, and who was permitted to remain in court under the victim statute if they were in fact a witness, and who was not. So if counsel could just keep that in mind. And then secondly, with it being live streamed, certainly that gives anyone an opportunity to be observing and watching the trial before they testify. And so the court is going to be requiring a witness to testify under oath that they've not been observing trial proceedings before they testify. Otherwise, if I find they violated the exclusionary order, then they may not be permitted to testify. So, Ms. Blake, then on behalf of the state, if you would just keep that in mind in terms of who's going to be in attending trial that may be a victim and witness, in addition to making sure you instruct any potential witnesses that they're not permitted to observe the proceedings on the live stream or in any other way before their testimony, then we'll try to avoid that situation coming up at trial.
Your Honor, I think we're finalizing any list of people that intend to attend the trial in person. In anticipation of an exclusionary rule, the state has sent out a letter with our subpoenas, which we always send out. We did add a section regarding the exclusionary rule, advising the witnesses that we believed it would be this court's intention to put that into place, that they would be questioned about it, and that they should not be watching or observing any trial unless otherwise permitted by the court, so such as the victims.
All right. Thanks for the representation there, Ms. Blake. Mr. Pryor, any concerns or questions on, and at this point, I guess it is just my intention to have an exclusionary order entered. I'll ask if there is going to be any objection to that. Mr. Pryor, do you agree that would be appropriate to enter in the case?
Judge, I think that is appropriate, and I anticipated the court was going to do that based on the Vallow trial. I included actually in my actual subpoenas, Judge, language that directed every witness that has been subpoenaed not to discuss or review the case, look at the trial. It's included as a part of the subpoena that was issued. So if the court looks at some of the subpoenas I'd issued, you will note that there's a section on every one of my subpoenas that talks about the fact that they are not to observe the trial proceedings under any circumstances. So law enforcement officers, all of those folks have been directed to do that. My only concern, Judge, is that many of my witnesses are going to be witnesses that need to be subpoenaed and aren't necessarily would show up voluntarily. So I'm concerned that they may use that as a mechanism to get out of testifying. But if that's the case, we can discuss that during the trial if I think that has occurred. But, other than that, Judge, I agree with your exclusionary rule, and I think it's fair to invoke that. In terms of, I understand the state's going to have some victims there. Previously, Judge, the court allowed me a couple of seats for the Vallow trial. I would like the same opportunity to have 2 to 3 seats if possible. I have, I believe on my list, 7 expert witnesses, Judge. And my expert witnesses are obviously not covered by the exclusionary rule. They're allowed to view the proceedings as experts. And at various stages of the trial, I'm going to need these experts to have an opportunity to be able to sit there and view some of the proceedings. So I'm not particularly comfortable with live streaming or letting them view that live stream. I don't have a lot of trust in what's going on there. No offense to the IT people, but I'm going to need some seats for those folks to be present during the trial. So.
Okay, well, I'll certainly be able to accommodate some designated seating for approved personnel that might be assisting in the defense of the case. We can discuss that before, once we get started with jury selection process, we'll take a look at the courtroom and designate some particular seats, and that would apply also for the state to have some designated seating for certain individuals that are approved and not subject to the exclusionary rule. Ms. Blake, then just going back on that, does the state have any objection if the court just enters a written exclusionary order prior to commencing trial?
Judge, I think as a general rule, the state does not. I think sometimes a concern comes up that if witnesses are not inclined to testify, they may intentionally review or view some testimony as a mechanism to try to avoid testifying. Only for that reason, I don't know if the court believes that it would be appropriate to do some kind of an admonishment at the outset, in addition to the written order, just advising something along those lines. We don't want to run into that situation for the state or the defense witnesses.
I concur, Judge. That's my only concern is that the state's aware of my witnesses and some of those folks may try to do that. And if that's the case, we're going to have an individual hearing. I hate to think that people would do that, but if that happens, the state that they may have people who may try to do that as well for the defense. So exclusionary rule is fine, Judge, but maybe leave the opportunity to address individual witnesses if we find their behavior may not be entirely pure.
Understood. And it's an interesting concern, but I think it can be resolved on a witness by witness basis if it comes up. The exclusion, of course, is discretionary. If the court finds there's a violation, it's not an automatic sanction or really even governed by any rules. So if I were to determine someone had tried to intentionally avoid testifying, they can still be compelled to testify, brought in under subpoena and required to testify. It would just be a question of whether or not that's influenced their testimony in any way, but certainly does not automatically preclude them being required to testify. And I would likely compel someone to testify if, in fact, I thought they were trying to use that as a shield against being required to testify. So hopefully that doesn't happen, but I would instruct counsel to, of course, advise anyone that you do intend to call if you have an opportunity to talk to them, that that's probably a strategy that would not be effective if they thought it was going to be. All right, so what I'll likely do then is just, so I have it in the file and everyone's aware, we'll get an order issued sometime before trial starts that will provide for the exclusion of witnesses. The other matter I wanted to bring up before we went on to some more nuts and bolts of the trial proceedings, there was a motion that had been filed, not set for hearing or determined. The defense filed a motion on January 30 to extend time for expert disclosures. I did briefly address that yesterday. I understand, Mr. Pryor, that based on the state's response and further proceedings, you're withdrawing that motion and do not intend to get a ruling on that. Is that correct?
It is correct, Judge. At this time, we're withdrawing that motion. It was more of a protective mechanism based on some information that the state disclosed to me, some evidence. They did that within the time addressed by the court and permitted by the court. There was no issue. It was just, I had some concerns. Those have been alleviated in discussions with the state, so we're prepared to go forward.
All right, then the court will not schedule any hearing or make a determination on that January 30th motion, and the court will deem it withdrawn at this time. The final procedural issue I wanted to bring up was the filing of an amended indictment, which the state filed 2 days ago. Mr. Pryor, were you aware that an amended indictment was filed in the case?
Yes, Judge.
All right, on that amended indictment, given the timing, I guess I want to make an inquiry as to whether or not the defense intends to raise any challenge to the amendment on the indictment. And if so, we'd probably need to look at scheduling a hearing on that.
I apologize, Your Honor.
That's fine. So the court would note that amendments of indictments are allowed at this stage of the proceedings. So I guess I'm wondering if you intend any challenge to the amended indictment or whether or not there won't be a challenge. So just for scheduling purposes, if we need to have any hearing on that issue before trial.
And Judge, I think if the court recalls, the state filed a motion to amend the indictment. What they didn't do is, and I was aware of this, I've had a number of discussions with the prosecutor, they just didn't get the amended indictment based on the court's ruling finalized. This is the final draft. I believe it's consistent with what the court ruled. So at this point, I won't be filing any objection to the amended indictment, nor will I be challenging it in any form at this point.
Okay, thank you for that. I just wanted to make sure. So to be clear then, the court will be proceeding through trial with advising the jurors under charges as listed in the amended indictment filed on February 20th of 2024. And the court will note at this hearing that the defense raises no challenge to the amended indictment. And also, as you've stated, Mr. Pryor, there was previously a hearing and a ruling on that. And the court finds also the amended indictment comports with the court's previous ruling. So that will be the governing document as we go forward. With that, then, I guess going towards trial itself, this would be the time if either side has any questions or concerns that we haven't addressed or that are appropriately addressed on the record here in terms of trial length or any of the policies the court will be employing at trial, beginning with the state, Ms. Blake. And I guess one thing I would ask, if you have any estimates on where you think things stand in terms of the trial length, I'd like any input on that. We've scheduled it through the end of May. What are your thoughts on that, Ms. Blake?
Your Honor, I believe that is still an appropriate end time to put for the trial. I think the parties are committed to seeing if we can move things along. Some of it will depend on how long jury selection takes. I think we'll have a better idea. But I still anticipate right now the trial running through the end of May for scheduling purposes.
Okay, thank you. Anything else you'd like to bring up other than advising the court if, in fact, the state's ready to proceed on those dates?
Just two things briefly, Your Honor. Just regarding the amended indictment so that all parties are clear as well. The state had emailed out a copy. In that copy, we'd italicized some things to make it very easy for everyone to follow along what the state was requesting be modified. All we did was took that and unitalicized those and then filed it in once we realized that we'd failed to get it actually filed. So just so the record's clear on that as well, that's where that amended indictment came from. So all parties had a copy previously. Outside of that, the only other thing that I can think of right now for the state is we will have a few additional motions, specifically some motions in limine right now that we would intend to file. We're hoping to have those filed next week. I don't know if the court would want to set a hearing date now or if we want to set a hearing date once they're filed, but just so the court is aware, we will have a few additional motions being filed.
Okay, I'd prefer to probably see the motions and figure out in my calendar where that fits in. And then the other issue, I'm sure, for Mr. Pryor's convenience is whether or not those would be required to be in person or remote hearings if they're going to take place between now and the start of trial. So once those are filed, we'll contact counsel for scheduling hearing if we want to do that before we start trial. All right, from the defense then, Mr. Pryor, your thoughts on the time we've got set aside for this trial and any other issues you think need to be addressed today?
Judge, I think it's an appropriate amount of time. My only concern is that the court's well aware I have a significant number of witnesses. There is going to be some overlap, and I've told the state some of those witnesses I'm just not going to call. It depends on how the case for the state proceeds. But one of my concerns is I have 7 experts. I'm preparing them to come in and paying for them with their plane and hotel and all of that stuff. And these are busy folks, and I've blocked out some time, and I've started that based on discussions with the state around the second week of May is what I'm anticipating, the 15th or so of May. My concern is that if the state's not done yet, that could delay things and cause this thing to go beyond the end of May. The other issue is that if the state's case ends early, I'm going to be scrambling to bring witnesses in to cover the time when the state finishes. So is that a concern of mine? It's a significant concern because these are not cheap experts. And if I have to fly them in a couple of times, and one of the things the state and I discussed is that when they call various witnesses and there's a lot of duplication, that we be given each some leeway in terms of our examination so that we don't have to recall a number of the police officers that are being subpoenaed at the present moment and that are subpoenaed, so that we can maybe move this thing along a little more expeditiously. So I don't know if the state wants to discuss that now, but Judge, there is a lot of duplication. A great number of my witnesses are already witnesses that were called during the Vallow trial, and I anticipate them being called. And one of the concerns is I'm not going to release them from their subpoenas, but I don't know how the court would rule on maybe giving a more expansive direct and cross-examination to allow this to proceed a little more expeditiously.
All right, well, at this point, I wouldn't make any ruling. We just have to see how that plays out in terms of presentation of evidence. But in general terms, I do try to, for efficiency and also just to move things along and not inconvenience witnesses. I don't usually like the practice of putting witnesses on the stand and then having them come back later and being recalled. I think once they're there to testify, if there's a way to get all their testimony out while they're there on the stand, that's my preference. So in terms of latitude of who's doing direct or cross, I think we can work with that as the witness is testifying. And sometimes there is a reason why witnesses come back later, and so it's not a foregone conclusion. But with your concerns there on timing, I guess, Mr. Pryor, you just have to try to make your best estimate of when things are going to be happening based on what you think the state's going to be doing. And it appears the parties are working together, but obviously I'd ask the parties to coordinate as much as possible for timing purposes. And I know the state probably has the same concerns with when people are lined up to testify. And the thing we want to avoid, obviously, is some big delay where there aren't witnesses ready. So to keep the trial moving. All right, well, counsel, Mr. Pryor, do you have any other concerns before we conclude today then?
No other concerns, Judge. I will note that there was some discussion at the status yesterday, Judge, about a stipulation regarding a significant number of exhibits that both sides are going to stipulate to and agree that they can be entered as part of the record. And the state provided me a list of that late last night. I'll get that back to them hopefully tonight or tomorrow, and that'll help in the planning of this, because we do have a significant list of items that we're going to just allow in to state, and I have been working very closely in trying to get that taken care of as well.
All right, I'll note that I am going to be in the short future here making a trip over to Boise for planning purposes. And one of the things I'll do there is confirm, we had some clerks that were cross-deputized in Ada County at the last trial. I'm not certain who is going to be assisting with clerk duties there this time and whether or not they are still cross-deputized or not. But the point of that would be, if you have exhibits in lieu of bringing them over here and having them transported back to Ada County, if we have a cross-deputized clerk there that can take custody of those exhibits before trial, they could just go directly to the Ada County Courthouse.
And Judge, could I have some time frame as to when you want that done? I would assume probably the latter part of March.
Just probably really any time before trial, or even as we're starting with the jury selection is going to take a while. So even during the jury selection time, I think we could work on getting exhibits in and submitted into the record.
And I'm aware the court has an order that allows us to disclose all of our exhibits and our witnesses by the 10th of March. And I assume that I can do that by email to your clerk and counsel, and they can do the same. Is that correct, Judge?
Yeah, that will be an acceptable way to comply with that part of the scheduling order. All right, Ms. Blake, then anything further from the state this morning?
No, Your Honor.
All right.
Sorry. No, Judge, that's all. Thank you, Your Honor.
All right, counsel, that'll conclude the pretrial conference then. The court will keep in contact with you in regards to the jury selection process and timing of that. We'll get a proposed schedule out. And for those motions in limine, if you could get those filed. All right, we're going to go ahead and call it a day then on this pretrial conference. Thanks for your attendance, everyone, and we'll be in recess.
Thank you, Your Honor.
All right.
Well, there we have it. Thank you guys for joining me so quickly. It was a last minute thing to decide. I wanted to get this on record for prosperity since the trial is coming up so soon. And I was really curious if they were going to go with that motion for extension, which I'm very happy did not actually occur. Looks like we're still on schedule for April. There's a couple of things that still have to be decided, but those motions can always be taken care of at trial, like he said. So I'll keep an eye on the feed. I will go look for those actual amended indictment, and I will get that all together, the language, make a link, a shareable link, and I will put it in the description of this one, and also I will put it in the Discord for those of you that are members that are in the Discord. It will be in the Daybell trial room. But I will actually put it on this one also in all future, get it into the information for Daybell somehow so that you have it. Thanks, guys. I think that's the end. I'm going to put the outro on. And it was nice having a little coffee break with you this morning. The other trial that's going on today is in the Rust cases. It is Hannah Gutierrez. It is New Mexico versus Hannah Gutierrez, who was the armorer. Okay, and I was watching the opening statements, but me, I like my enthusiastic lawyers, and there was not a lot of enthusiasm there. So I will be reporting on the what actually happens during the week periodically in my updates on the case, because I am more interested in actually doing the live streaming when we get to the Baldwin part, because I think there's much more going on there legally. I kind of believe I'm a little too biased in the Hannah Gutierrez case. I've kind of like looking at everything side-eyed, and I think it's a slam dunk. Maybe I'll be surprised. We'll see. But live streaming, as you all know, takes a lot of time, like 8 hours of a day. and it could be quite tedious. And this part, I don't think there's enough there to hold your interest. But Law and Crime and Court TV, as well as ABC, KVLAO, and the AP, or actually the AP Press, are actually streaming live, so you can get lots of coverage if you want. Yes, no banner. I'll put it on just for the ending. Liam, it's good to see you. Thanks for reminding me, but I didn't want to play it during the trial anyway. But you guys all have a good morning. Remember, coffee is life. Have a second cup of I'm gonna go pour me another and get to some other research for some more true crime during the week. I will see you all again really soon. Thanks for hanging with me.